So thank you everybody for being here. This is our first meeting of the reactivated Bench Bar Foreclosure Committee. And today's meeting is just for everybody to meet fellow committee members and to sort of get them all rolling as far as what things you think might be appropriate for us to address in future meetings, and to do a couple housekeeping items. And probably most substantively, Becky has a report that you'll see on here under the discussion of the foreclosure standing orders with some information that she has. So that's my welcome and my call to order. And I'm going to ask, rather than doing Becky needs attendance, but rather than having me just call the attendance, I'm just going to ask if each of you want to just give like a quick intro of yourself. So we'll start with, let's go alphabetically. Judge Abrams.
My name is Jim Abrams. I'm now a senior judge. I'm the former chief administrative judge for civil, and I've been doing foreclosure since 2009, I think, when I went to New Haven. So I have some institutional knowledge. My up-to-date experience is probably less than everybody else, but if you want me to answer what happened in 2009, I may be a decent resource for that.
All right. And well, why don't we do the judges alphabetically first? So Judge Morgan, I'm skipping over myself. I recognize I'm a B, but.
All right. Good afternoon, everyone. I'm Lisa Morgan. I'm the AJ and the presiding judge of civil in New Britain. I do backup foreclosures to Judge Shortle, who is our primary foreclosure docket. JTR handles them on Mondays, but I do anything that gets sent to our way on foreclosure matters on the days that he's not here. I also did foreclosures in Middletown, and I did them in private practice.
All right, Judge Rohrbeck. Wait, do we still have him? Did he go away? Oh, when he comes back, we'll have him introduce himself. Judge Spader.
Hi, yeah, Walt Spader. Currently in the New Haven, and I do the foreclosure dockets in New Haven and Waterbury. I was doing them in Bridgeport and Stamford as well, and doing them in New Haven prior to that. So I've been on foreclosure dockets 6-7 years now, 6 years, and did have some experience in private practice before then. So got a lot of handled a lot of cases over the past few years. So if it's old stuff, we can talk to Judge Abrams about that 2009 decision. 2022, I may have written it. So.
All right. And then we have, let's see, Attorney Generous.
Good afternoon, everybody. My name is George Generous. I am now with Brock and Scott, was with Bendett and McHugh for quite some time. We have now merged firms, so everything's all the same, but much more confusing. I have been practicing at Bendett for approximately 10 years now. Prior to that, I was clerking for Judge Satter, Judge Argema, Judge Rabina, various other judges in Hartford, all of whom seem to have ended up doing foreclosures at some point. So I have quite a lot of time in the foreclosure realm, and have been working in private practice since about 2012.
All right. And our newest member of the committee, Attorney Gentis.
Hi, everybody. I'm Jeff Gentis. I'm with Connecticut Fair Housing Center, and I co-supervise the housing clinic at Yale. I have been doing this work since the beginning of 2008, initially in New York, and then came to Connecticut in 2010, and I was on the first 1.0 version of this committee.
Excellent. All right, and let's see, Attorney Pocklington.
Good afternoon, everyone. I'm James Pocklington. I'm a partner with McCallum Lieber Pierce, formerly Hunt Lieber Jacobson, but I think all of you do that already. I've been here doing foreclosures from this perspective since 2010, and prior to that, I actually did the reverse of, instead of private practice and then to the court, I was foreclosure clerk down in Middletown for Judge Holzberg and Judge Taylor, Mark, not Carl, back in the day in my prior life.
Right, great. And Attorney Salato.
Hi, everyone. I'm Maria Salato. I was at the Marcus Law Firm for 6 years, and then about a year and a half ago, I came out on my own, opened my own firm, and I've done foreclosures my entire career.
And Becky Schmidt.
Hi, good afternoon, everyone. I'm Becky Schmidt, Deputy Director for Civil Matters at Court Operations. Prior roles in civil, which I recognize many of you from, was an original foreclosure mediation program casefill coordinator for Hartford. I also backed up the foreclosure docket in New Britain for quite some time and supervised the mediators.
And Attorney Sternberg.
Hi, I'm Jenna Sternberg. I started working with Pat Boatman in 2005, and I think we started doing foreclosure defense work about that time and did plenty of it early on up until recently. Jeff brought me in, I think in 2012, after we had had some success defending a couple of foreclosures that weren't being prosecuted appropriately. And Attorney Boatman is now on his way to retirement. So as of just recently, I'm not with him anymore and trying to figure out what's next.
All right. And we still don't have Judge Rohrer back. Are we able to invite him back in, Becky? Like is there a button to request that he join? I don't know if he went out voluntarily or.
I will, yes, let me request him.
All right. And then I think you all know, so I'm Claudia Bayo. Somehow I ended up as the chair of this committee. I think it's just because I like to plan things and organize things. So that, that's what I bring to the table as primary. But as far as foreclosure goes, I was the presiding judge of housing much like Judge Spader is and was in New Haven and Waterbury, and that assignment also includes foreclosure. And then when I was in Hartford, where I am for another few days, I was also in charge of the foreclosure docket here, and every once in a while backed up also in Waterbury. And so I think I have had all of you except for Attorney Sternberg in front of me on multiple occasions, and Attorney Generous did confuse me when he changed his firm recently, but I've gotten over that. And I have had the pleasure of learning foreclosure work from Judge Abrams and Judge Cordani, who's not here, Judge Rohrer, and of course my work husband Walt Spader. So I've had some of the good ones around me for foreclosure work. So I just wanted to remind you, some of you were involved. We also have the benefit of having folks that were on this committee, as you know, has been dormant for a number of years. And fortunately, they decided to reactivate it. And we have some of the folks that have the institutional knowledge. So it's not just that Judge Abrams can tell us about cases from 2009, and he's obviously being self-deprecating when he says that, but he also was on this committee previously, as was Judge Morgan. And Judge Spader, were you on it before?
I was not. I know
Okay.
I was on, I think, some subcommittees, like Lou Zellwein called me in on some issues here and there, but.
Yeah, so we have some folks that have institutional knowledge of this committee, which will be tremendously helpful as we try to figure out where we can be useful. I'm not sure if Judge Rohrer was on it before, but the mission, according to when it was originally established in 2007, and it hasn't changed, is to promote cooperation between the bench and the bar, and to address current practices in the courts regarding foreclosure cases and make recommendations on ways to improve those procedures and practices. And the committee itself, the makeup of the committee, which the appointments come through our Chief Court Administrator and Chief Justice. Hopefully you see in our Brady Bunch set that the goal here is to be diverse, both in the area geographically, as where you lie in the foreclosure arena as far as plaintiff and defendant, and also gender. And so we tried to make sure that there was a diverse group so that this was a representative group for the committee. In order to try to make this a meaningful committee, I don't like to over meeting people, but I also think that having some sort of structure is important. And so Becky and I were talking about setting a meeting schedule, and we thought that it would make sense to at least have it so that we could have it on our calendar. If we get to a point where there's something that needs a subcommittee or more meetings, we could always deal with that. If we get to a point where there's nothing for us to discuss, I'm not going to make you come to a meeting just because it's scheduled. But I wanted to throw out there the idea of scheduling quarterly meetings and see how people felt about that. Anyone?
Somebody's got to talk first, and those of you that know me know that I abhor a conversational vacuum, so I'll just start talking. Quarterly seems perfectly fine once we get in our groove. I don't know whether, depending on where we're going to leave today, whether we will want to wait until November and hit the holidays before our next meeting, but ultimately that really depends on where we leave today. But quarterly in general, once we're there, 100%.
Okay. Anyone else have any strong feelings one way or another, or want to just pipe in?
I think quarterly makes sense for now. We'll see if it's too much or too little. Judge Bayo, do you know the last date this committee met? Because I can't remember it.
Yeah, it was, Becky, I know we pulled, that was 2014, correct? I can pull that up. I think it was 2014.
Yeah, correct. Your
Sounds
Honor,
about right.
2014.
Yeah, it's been
Just
a long
curious.
time.
Thank you.
And so,
If memory, excuse me,
Yeah,
if memory
no.
serves, it was about twice the size back then. Jeff, would you, and Lisa? I
Yeah,
like it
we
better
did.
this size. I think
It
it's
was a
far more productive. Would you agree, Jeff? Would you think it was about twice the size?
yeah, and it was yeah, there were more talkers, and it was Friday 2 to 4. And I want to say, and we might have been
Was in
close
East
to
Hartford,
monthly.
right? Or Middletown? Where was it?
In Weathersfield,
In Weathersfield.
in one of those the square,
Yes, yes,
the
yes.
tables
Yeah,
all,
we'd all sit around
Yes.
the table.
yeah.
Yeah.
I think it was close to, it was a little more frequent, but I think there was more evolution coming down, especially from the federal government in terms of what was required and what was involved. And I think, we survived 9 years without it, though. I'll have to dig it back up and figure out what was on my agenda in 2014 for the next meeting. But I think quarterly probably is a good place to start. And if we need to adjust, that all sounds perfectly good. Perfectly
Yeah,
well.
and those of you that were obviously involved at the inception know this better, but it looks like just from doing our research and figuring out what was done previously and how this sort of had evolved before it ended, it appeared that, as you indicated, Jeff, there was a lot of change happening, but also it seemed like that was the time where a lot of the standing orders were first being, I say first, there were some, but were being developed, as opposed to now we have them and the question is reviewing them. Does that sound right to you? That's what it looked like from the minutes.
Yeah, and I'm looking at the minutes now and the dates of those. I think the subcommittees were pretty hot.
You had a lot of subcommittees. So
Yeah.
that's another thing we're going to have to talk about. I didn't want to have this be like a crazy first meeting with a whole lot of things going on, some of which may not even be relevant anymore. But one of the things that we're going to have to determine, and I welcome the input on, is what if, so for your homework, for your brainstorming, what if any of these subcommittees or others might be appropriate. I will just tell you, if you don't have them handy or you don't have them in your memory resources, the subcommittees that were set up previously were the process subcommittee. And see, some of these things, when you hear them, you're like, okay, that's already been resolved. We don't need that anymore. So these may not be things that we have in the future. I'm just telling you what was there before. The process subcommittee, the supplemental judgment subcommittee, the committee subcommittee, the short calendar subcommittee, subcommittee on investor restrictions, subcommittee for motions to open judgment, subcommittee for real estate conveyance tax, subcommittee regarding recording of documents and notice to mortgagees, the summary judgment subcommittee, the Federal Loss Mitigation Affidavit Review Subcommittee, and the Standing Orders Review Subcommittee. So as I said, some of those may be like, we don't need them anymore, but I'm just telling you to kind of get you to start thinking about what, if any, subcommittees might make sense. At this point, we don't want to create unnecessary work, but we want the committee to be meaningful. And I guess this kind of dovetails into the next topic, which is discussion. We have discussion of future topics. Basically, it's to come up with what, if anything, we feel would be appropriate for us to start tackling. And the first thing, there's Judge Rohraback. He's back. The first thing we thought was the review of the foreclosure standing orders and the consistency or lack thereof between any local standing orders that might be in place and whether those make sense. I will just give an example. One of the issues that has come up in Hartford is that the standing order relating to the cost of signs is apparently lower than a number of other jurisdictions. And most of the sign vendors don't have an issue with that, but there's one particular sign vendor that has had committees send in requests to try to get paid more for the sign. So the question is, are issues like that with the payments of signs and the various orders that relate to the jurisdiction something that, it's going to vary. I get that, but is that something we need to address? I wanted to, in a moment, turn it over to Becky because coincidentally, she was tasked with doing a review of the standing orders, including the foreclosure standing orders for Judge Bellis. And so she was going to give us a report. But before I do that, because I know I just threw a lot in there, does anybody have anything that comes to mind that they want to share as it relates to the idea of topics, subcommittees, that kind of thing?
I don't know about subcommittees, but I think it would be helpful if we somewhere posted something on the judicial branch website that could explain to people how the foreclosure dockets are handled in each of the respective districts, because I think it's a mystery for the lawyers who don't practice in that area all the time to know whether they're handled remotely. And I know Becky is going to speak to this on the issue of the standing orders because I know that there have been some issues raised with the standing orders, not only with foreclosures, but on the civil short calendar. But I think it would be helpful if we let people know that in New Britain, they're done remotely and you don't come to court on the day that the short calendar is marked ready, and that they're done in blocks at 10, 11, and 12. But I think it would be helpful to have something out there so people who practice in different districts knew how it's handled in each individual district.
That makes good sense. Anyone else? Everyone's nodding in agreement at your very good suggestion.
I would, on a related point, I know there's been different evolution. I've even talked to Judge Abrams a couple times over the years, or I've heard him say things and made it back to me about the remote versus in-person nature for pro se defendants in foreclosure versus, say, housing session. And to the extent that there's a any desire to have a uniform policy, this might be a good forum for discussing the pros and cons for those.
Any other thoughts? All right. Then I'll move on to Becky.
So it's not a lengthy report, but in conjunction with the new term, Judge Bellis and Judge Pizzuto have asked that we review court ops, the standing orders that are currently posted. And as many of you are aware, some of them date back to 2014 with this committee's work on foreclosure standing orders in particular. This committee was very heavily involved in the orders that are currently posted, and just due to time and to COVID and other factors, upon review, those standing orders are now out of date and not as informative as we would like them to be. So we are undertaking a review of those, and I think that the expectation would be that this committee would be to some extent involved in that, since it was so heavily involved in the drafting of those orders to begin with. For instance, legal notice is very different now. We post on the website, so there's some discrepancies in the standing orders between, newspaper posting versus the legal notice page. Your documents for foreclosure uploaded as exhibits for remote proceedings, those sorts of things that have kind of become standard practice, but not as documented as we would like for, purposes of transparency and ease for practitioners and the public to understand when they come to court what is happening. So that's my brief update. I would expect that we'll have a lengthier one at some point in time for you regarding that, as well as some input from this group.
Thank you, Becky. Does anyone have anything for Becky? All right.
I do have a question, actually.
Okay.
When you talked about how different, how different JDs are doing it, posting it, there in the past, there's been some reluctance among the powers that be to show any difference between JDs. And I suppose that would go to Judge Bellis and then to Judge Bizzuto, but is your sense, Becky, that that's a little less of an issue than it may have been in the past?
So my sense of it is that there's a lot of judicial district specific practices, as well as the overarching here's the process from the practice book perspective and from the standing orders that we have currently posted. So we're reviewing to make sure that those are in agreement with each other. And there's a lot of, I don't want to say, there are processes and procedures that arose during COVID to facilitate the remote process that are continuing and that need to be documented now for what we have out there. So just reviewing in addition to the standing orders and what Judge Morgan has raised, which is the calendar notice. That's the short calendar notice that goes out to the parties. We have, information about how that is handled and directions to the field, but now we are going back and documenting that so that there is just ease of process for people who are using it so that they know what to expect. So to Judge Morgan's point, although the calendar printing is governed by practice book and is regimented, there are different ways that the districts have of facilitating that process. So ultimately what we end up with, I'm not sure. I don't want to make any promises here to this group, but we are looking at that and at our other documentation that flows from that. So there are a lot of quick cards that are out there that are out of date that reference the old process that need to be reviewed. And it's just trying to identify if you've ever looked at the branch website. So as practitioners, you may know what to expect when you go to court, but there are so many places where there's information that we need. When we make an update to one thing, we need to catch it in a bunch of other spots to make sure that it's correct across the board, because a lot of people are accessing it through different pages or through our quick cards. So we're undertaking that kind of a review, and I would expect to have more information to share with this group in terms of where we've identified those, explanations of those procedures. Kind of where they live on the website and where they're presented to people who access the court process. So I guess I'm not sure that answered your question, Your Honor, but that's kind of where we are in terms of we're at the beginning of kind of gathering all the information so that we can then determine what needs to be done to make sure that we're providing the information appropriately.
Thought in that regard is just from a practitioner whose office gets notices from every JD. One of the things that we've definitely seen where there might be some opportunity to smooth some of those differences for practitioners that don't practice everywhere are the notices. And each court, for example, has a different notice template for a lot of things. Some are consistent. The notice of judgment of strict foreclosure, 100% consistent because of the way it's coded into the system. But the notifications of a remote hearing being scheduled, who you contact, how far ahead you contact, et cetera, does seem to vary between different jurisdictions. So having that centralized whether it's made uniform or just this is how it is here and this is how it is here, all in one place for ease of practitioners outside the normal that district, could be really useful.
And not just practitioners, the confusion comes with self-represented parties. I mean, like who are, the practitioners may have an attorney friend they can call, but the self-represented party may not know someone who is in court all the time. And I get it, even on my docket yesterday, one of the defendants like, hey, I got 2 different notices from the court. One said, don't come to court on this date, and the other one said, your court date is this date. So I'm here, but can I have a 2-week continuance? And yes, I gave the 2-week continuance, but it does, you have that situation where the self-represented party is more likely to be confused in that situation because they may not be in communication with the other attorney in the case as attorney to attorney saying, hey, the hearing's Monday, I'll forward you the link if you didn't get it from the court. So we do have to be concerned with what the self-represented parties receive from us.
Right, and I think this goes back to Judge Morgan's original suggestion, which is to have it somewhere posted how the dockets are handled in each district helps to bring that. You're right about the uniformity, but it helps to bring it accessible to people to know, depending on where you're practicing. Quite frankly, it's good for the judges too, because when we move around, we have to figure out how the different districts are doing things too, if there is a difference. Attorney Generous, were you going to say something? I apologize if I
just wanted to point out, I think a lot of the confusion between not only self-represented parties, but other attorneys that I've noticed recently is now that we're doing things remotely, the calendar marking process has gotten to be very confusing. We have attorneys contact our office all the time and they say, hey, we had a hearing on Monday on this file. I can't be there. I need a continuance, when in fact it was just marked on the calendar and a remote hearing hasn't been scheduled yet. So I think that's where a lot of the issue, it used to be much simpler. If something was marked, it was going forward on Monday and you would show up on Monday for calendar and it would be there. But the different scheduling for the different courts, I think, has been a little bit of a speed bump for people to try to figure out exactly what's going on. I'd say 5 times a week I get a call or an email from an attorney asking about a motion that's on for Monday, when in fact it's just marked ready and there hasn't been a hearing scheduled yet. So that's definitely an issue I've seen come up quite a lot lately.
And forgive me for being underdressed. I'm on vacation, and forgive me for going missing. I brought my laptop home, but I didn't bring my power cord home. I was looking in my car. Did I get the power cord? Did I not get so my laptop went dead. So now I'm on my phone. But setting all that aside, to Judge Kelly Morgan's point, it's not unique to the foreclosure docket. It's also plagues us when it comes to civil short calendar markings and the inconsistencies in practices between and among the judicial districts as to whether or not they're conducting those proceedings in person or remote or some hybrid of that. So not to expand the scope of this committee's work, but I think it's something that maybe should be thought of in that holistic manner.
I thank you, Judge Rohrbeck, for being here while you're on vacation.
Or not being here as a maybe.
Attorney Moore, or Judge Morgan, you have your hand up. You don't have to put your hand up.
Question for the practitioners. Is anyone doing the foreclosure hearings in person, any of the districts?
Sometimes certain judges, Judge Shaban in Danbury, Judge Murphy in New London, they, especially if both sides are represented by counsel, and if there's trying to be descriptive without being editorializing. If there's some perhaps point that requires more elucidation, or there, it happens in federal court too, where it just things that handled over the phone, sometimes the judge brings them in person for some particular reason, perhaps to incentivize maybe even a dialing down of the temperature.
But it's the exception rather than the rule. So there
I
will be
think so.
one-offs that come in live.
Yeah, but they're still getting the same sort of, a lot of the pro ses are still getting the short calendar notices that don't necessarily explain what's going on.
And does the bar like it remote as opposed to live? Is it your preference?
100%.
Yeah. I mean, you get the, I learned how to become a lawyer by watching short calendar and sitting and watching it. And but you still get that with everyone who's doing, everyone I think has moved to block scheduling in some way or another. So you still get to watch all these things. You still could like log on a day where you're not in court and have, the YouTube streaming for most courthouses and still watch, still get the benefits of that sort of thing. And yeah, it's different to not, the relationships are not, do suffer a bit for like anything else remotely with your, fellow counsel as, when you're remote versus in person. But I think on the whole, especially with the decrease in volume overall, it's, you end up, people would, they can take cases they otherwise wouldn't. They can, it makes more sense to appear, if you only have one matter on as opposed to 3. And then I can imagine, especially with James and George's firms, the number, the fact that it's not just remote, but it's spread out over the week to some extent makes it much easier to staff.
Although I have to say, I think Attorney Generous, I don't know that this is something that happens all the time, but I know we had a situation where you were on my remote calendar and you had a live proceeding, and I had to make sure that we gave you enough time. I don't know that you necessarily, that caseflow necessarily notices when they're scheduling things that the same attorney who's there for, a number of matters on the remote proceeding might only have a half an hour after they're done to get to the courthouse for a live proceeding.
I think thankfully that day, I believe our calendar was done around 11 and the hearing was at 2, so it worked out. But yes, it does make it much easier, especially when we have a limited number of attorneys and 6 to 7 calendars going on the same day, that someone can cover, for example, Litchfield and then cover New Haven after that, or cover a court that has calendar in the afternoon and a court that has calendar in the morning. That definitely makes it much simpler. I would not wish anyone to have to drive to Litchfield and then drive to Stamford the same day to do a calendar. So it definitely is much easier, especially not necessarily for short calendar, but for mediation wise, it's much easier to have them remote because the mediations are spread out all over the state, of course, throughout the day. So we used to have to go to multiple courthouses in a day, and now being able to do them remotely is much, much easier.
Not only that, but if you just jumping right in, because that was perfect, George, thank you, is that it's not just a ease of thing, but it's a efficiency thing as well. I can't tell you how often I've been on a remote docket and someone has caught something that back in the day of physical attendance would have required either a off marking or an over marking, say a missing merger document or an assignment that was poorly scanned or something along those lines, which meant it probably was poorly printed when it was being sent. But ultimately, being able to fix that in real time by being in the office makes the process a lot more efficient. And I've seen similar things to what George is describing, especially from a homeowner perspective in the mediation context. So back in the day when we were physically attending mediations, the number of times a homeowner might have left their financial paperwork at home or not brought everything that they would have thought to bring. And it's, oh, okay, can you take 2 seconds, go to the other room and go get that, and they come back and they sit back down in front of the computer. There's a lot of efficiency gained by letting people do both short calendar and mediation from where they have the materials that they need to be most effective. And to your question, Judge Morgan, the couple of in-persons I've seen have been, in the last couple of months, have been either something very exception-based based off the file, or I've seen a handful, I want to say 2, maybe 3 now, that have been done as ADA accommodations. So the branch is being very good about making sure that those people that are not able to use the technology either have access to the remote rooms, or even with the remote room wouldn't be able to use it properly, have a regular traditional appearance.
Okay. Good, thank you.
Anyone else? All right. So it seems like, and as you know, as I said at the beginning, our role for this committee is to determine whether there are recommendations that can be made. So we're not, it doesn't end with us. It starts with us, and then whatever we think would be a valid recommendation then gets turned over to the administration to determine if they agree with us and want to do it. But it sounds like, and please tell me if everyone agrees with this or if I've missed something, that Judge Morgan and James's suggestion of, and others piping in, but suggestion that we come up with some sort of way to post how the various dockets are handled, almost in conjunction with, I mean, Becky's going to have a more detailed report for us next time, and we can figure out how that dovetails with the issue of the standing orders. But at least as something that is helpful, it seems like that might be a good starting point. Am I missing something?
Not missing it. I'm just going to take it one step further because that's the way I am. The branch did a great job with a how to do the technology that's attached to all the remote meeting invites. I think just a how to deal with the practical, not the technology of remote, is kind of where it goes from here. Just in terms of here's the practical, here's how New Britain does it, here's how Hartford does it, just so it's all a useful one-stop shopping.
All right, so maybe we make that one of our first tasks. Does that make sense to everyone? All right, so I promised you that this was going to be a short meeting and I was going to try and end it in a half an hour, and I'm a little bit over. My apologies. In the future, we will have another sort of catch-all agenda item that says other business in case there's something in particular someone wants to talk about that doesn't fall under one of the categories that we've raised. But I think at least from a general standpoint today, I tried to make the topics generic enough that we could at least have a good first discussion.
The only question I would have, because I know I need to end the meeting, and this question more for Becky. I know you're working with Judge Bellis on the standing orders and those issues. If we do a quarterly meeting, do you need something from us before the next meeting that would help? I don't know what your timeline is, but I can't imagine Judge Bellis would give you an open timeline of just that, do this in a few years from now. Like, is she looking for recommendations from you like in the next couple weeks? Whereas if we're not meeting till November, you might not get recommendations from us until November.
I don't have a hard deadline to give you, but yes, very much in agreement that it is not a years out in advance. It's more of an as soon as possible within, you know, the limitations of staffing and availability that we have. So I can certainly reach out to Judge Bellis and let her know that the committee has discussed undertaking a review, and to see if that's something that you know, we need to schedule more time to do.
Well, that's what I was going to suggest. Maybe you might want to send us an email appointing a subcommittee on the standing orders to have their own meeting to try to get something.
We have to propose the standing committees first. I mean, the subcommittees first. But let me just say this, though. Becky's undertaking of the review for Judge Bellis was something that was independent of this. And actually, when I talked to her about what we wanted to do for this committee, that had already been tasked. So I don't know that necessarily Judge Bellis was looking to wait for recommendations from us. Becky, am I getting that right?
Correct. I have not talked to her directly about this committee's involvement with that, since this is the first meeting in quite some time. But yes, the task was entirely separate and predated kind of the reformation of this reactivation, if you will, of this committee, and is actually broader than just the foreclosure orders. But with the understanding that this committee was just very much involved in the orders as they are drafted and posted today. So, you know, certainly I don't want to speak for Judge Bellis. I think she would be very open to feedback. She's always, you know, very accommodating to taking in feedback from, you know, all stakeholders when she's reviewing something. But that may be something that gets, you know, updated and posted prior to our meeting, and then feedback may be provided. So I can certainly, again, ask her and report back. If you prefer, Judge Bayo, I can report back via email, and there can be a determination made to see if we want to meet earlier or not. But I don't have a hard timeline from her on that.
and when I said quarterly, this is an introductory meeting, so I didn't necessarily mean we had to wait till the holidays for our next meeting. What I thought is after we had sort of discussed this separately, but that once the new term starts, maybe we schedule a meeting towards like the end of September and then start the quarterly meetings from there. And again, if we need to do them more than quarterly, we can figure it out. Thank you, James. I saw the thumbs up. We'll take a vote and see if everybody's okay with that. But you know, we can change it. Right now, it's just to sort of make sure that we don't fall off the radar. But is everybody okay with that, or do you have another suggestion? And then Judge Morgan, I see you have your hand up.
So I'm going to throw myself under the bus, which Becky has so far not done. But I'm probably, I raised some concerns with the notices a week or so ago, which is why this notice problem has been stalled. And I did happen to speak with Judge Bellis earlier today, not with respect to this foreclosure committee, but with respect to the notices to Judge Rohrbeck's point. It applies to the civil notices and the civil short calendar as well. But when I spoke with her today, she had said, well, we're going to focus on foreclosures first and see if we can't get that going. So I will volunteer to work with Becky and interface with Judge Bellis, if you don't mind, Judge Baio, and maybe put some thoughts together and get clearance from Judge Bellis so we can get this moving sooner rather than later and not have to wait until the next meeting.
That sounds great to me. Does anyone have any issue with that?
No issue, just for clarity, for whomever may be, reviewing this or watching it in the future. I was speaking to standing orders, which we're undertaking to review. This is the actual short calendar notice, which lives in a different system, if you will. And I am not the tech person to explain to you all how it works, but it is in a separate system from e-filing, although it speaks, if you will, to e-filing and pulls the information about what cases are on the short calendar from e-filing. But we're talking about the actual calendar notice that is mailed out to self-represented parties and that attorneys receive in their e-services inbox. So it's not a JD&O and it's not the standing orders. It's the short calendar notices, which are prefixed, if you will. They are standard across the state right now for the property docket, which is short calendar 2. And her timeline, I feel confident that Judge Bellis will forgive me for speaking for her. Her timeline for that was immediate, not a kind of review and suggestion thing. We will be addressing that immediately at court operations.
All right. Thank you for clarifying the distinction. I think this group understood that, but I understand for purposes of the record that distinction was important to note. So I guess just so that we're sticking with proper procedure, I would entertain a motion to make Judge Morgan our point person on that issue. Consistent with your recommendation.
Yeah, Judge Abrams, I know what you're thinking, Judge Abrams. This is why I shouldn't come to these meetings.
All right, so we had
enthusiastically moved.
All right, is there a second?
Second.
Any discussion? All those in favor? Aye. Any opposed? Any abstentions? All right, unanimously voted in. So
nice, thank you, Becky. How about if I call you tomorrow and we can discuss offline?
Sounds great, Your Honor.
All right, awesome. And then to Judge Spader's point, again, for the next meeting, if we can kind of start thinking about what subcommittees might make sense. If you think it's premature, I'll hear from you about that. If you think there's some that might make sense for us to embark on immediately, then we'll talk about that. Obviously, we don't have to have as many as were here last time, even if we just start off with one. This is all a work in progress, and we are open to suggestions. Is there anything else before I entertain a motion to adjourn? Actually, I should ask you, are there days of the week that are better for you folks if I have Becky set up a meeting similarly at 4 o'clock on a weekday in late September?
I'm not sure how this, what James's opinion would be on this, but Mondays are basically the worst day for anything. So
for everybody
other than Monday should be fine.
Anyone else? All right. So then, Attorney Gentis, were you going to say something?
I already let you know that I have another have a soccer related conflict starting at 5:30 on Tuesdays and Thursdays. And that's, that is
All
my
right.
actual job, not Fair Housing Center or Yale Law School. So
Right.
as long as we wrap it up by 5, those would be great.
All right. No, I know. I promised you I'd get you out on time today. So, all right, then with that, we will, anyone else have any issues we need to address? Then with that, I will entertain a motion to adjourn. Do you all want to stay? Second, anyone?
Second.
All those in favor? I see everyone, so there's no abstentions or nays. So with that, thank you very much, everybody. I look forward to your continued input. Thank you for your time today. And thank you, Judge Morgan. All right. Thanks, Becky.
Welcome.
Have a great night, everybody.
Thank you.
Take care, everyone.